Welcome, 1Ls, to this explainer. Today we're going to completely break down the landmark case of Harbhajan Lal v. Harcharan Lal and turn it into a high-energy, high-yield IRAC masterclass for your finals. Now, if you're currently studying the Indian Contract Act of 1872, you already know that contract formation can get, well, incredibly tricky, especially when we ditch the standard face-to-face agreements and step into the wild, unpredictable world of public rewards. So we're going to turn this specific case into your ultimate study guide so you can absolutely crush any exam question your professor throws your way. Here's our roadmap for the explainer. We'll quickly hit the facts, the core issues, the specific rules from the Indian Contract Act, the final ruling, and then wrap it all up with an exam review of the core legal principles. Okay, picture this because it's a super relatable scenario. Imagine someone's property is stolen. They're desperate, right? So they publicly announce a massive cash reward for information that leads to the recovery of their goods and the arrest of the thieves. You put in the hard work, you track down the culprits, you hand over the information, and then the guy who offered the reward pulls the ultimate rug pull. He just tries to avoid paying the bill. He changes his mind, looks at you and says, hey, you just helped out a fellow citizen. I don't actually owe you anything. Can he really get away with that? Can you legally force him to pay up? To answer that, let's start with Section 1, the facts. Stolen property reward. Getting this factual timeline down is exactly how you spot the legal relationship on your exam. This timeline brilliantly illustrates the exact chronological sequence you need to be looking for when you're reading a tricky exam prompt. Step 1. Harcharan Lal publicly announces a reward for information regarding his stolen property and the offenders. Step 2, and literally put a massive star next to this one, our plaintiff, Harbhajan Lal, actually learns of this offer. He knows there's money on the table. Step 3, acting on that specific knowledge, he provides the necessary information, successfully leading to the recovery of the property and the arrest of the thieves. He fulfilled the conditions. And finally, Step 4, the inevitable refusal. Harcharan Lal flat out refuses to pay the reward, which forces Harbhajan to take him to court. Moving right along to Section 2, the issues. Enforcing general offers. Let's look at how the court framed this intense dispute.
The court really had a knot to untangle here with these 4 specific questions. First off, does a general reward announcement broadcast to the whole world even count as a valid legal offer? Second, did Harbhajan actually have knowledge of it before he acted? Third, since there's no formal I accept your offer letter signed in blood, does the mere performance of the conditions equal legal acceptance? And finally, putting all those pieces together, is Harbhajan legally entitled to force Harchan to hand over that reward money?
What's really fascinating here is comparing these competing arguments, because this is exactly how you're going to want to structure the application section of your IRAC. On one side, you've got Harbhajan's rock-solid claim. He's saying, look, you made a public reward, I knew about it, I fulfilled literally every single condition you asked for, therefore you are bound to pay me. Against that, you have Harcharan's, well, somewhat desperate defense. He essentially tries to argue that a reward notice doesn't create strict legal liability. He says Harbhajan merely provided assistance, and hey, being a good Samaritan shouldn't automatically cost him money. He's trying to frame it as a casual interaction, definitely not a binding contract. Which brings us to Section 3, the rules, Indian Contract Act. Grab your highlighters because we are diving into the exact black-letter rules from the Act of 1872 that govern this scenario. First up is Section 2A. This section tells us that a proposal, an offer, exists when one person signifies their willingness to do something with a view to obtaining another's assent. Applying this directly to our facts, the court determined that a public reward announcement, it's not just empty talk. It is legally a valid proposal to the general public. By posting it, Harcharan signified his willingness to part with his money to obtain the specific act of finding his property. Next, we slide over to Section 2B, which gives us the definition of acceptance. It says when the person to whom the proposal is made signifies assent, the proposal becomes accepted. But wait, think about it. In a general public offer, how on earth do you signify assent? You don't call the guy up on the phone and say, I officially accept your noble quest to find your stolen goods. That's just not how reality works. So how does Harbhajan legally signify his assent under the Act? Enter Section 8. Honestly, if you remember just one thing from this whole explainer, let it be Section 8. It is the absolute, undisputed MVP of this case. It blasts through all that confusion about how to accept a general offer by straight up declaring that simply performing the conditions of a proposal amounts to acceptance. You do not need a formal declaration. Your actions are your acceptance. By finding the thieves, Harbhajan accepted the offer. Period. And when you combine that valid offer under 2A with that valid performance-based acceptance under Section 8, boom, Section 2H kicks in. Section 2H states that an agreement enforceable by law is a contract. This officially transforms Harbhajan's successful treasure hunt from a friendly neighborhood favor into a legally enforceable, ironclad contract. Let's transition to Section 4, the ruling, judgment, and ratio. This is the critical reasoning you've got to have memorized. Unsurprisingly, based on those statutes, the court decisively ruled in favor of Harbhajan Lal. The ratio decidendi, the core legal reasoning here is that a person who performs the conditions of a general offer with knowledge of that offer validly accepts it. It's that simple. Harcharan made a valid general offer, Harbhajan acted with prior knowledge, and therefore an unbreakable binding contract was formed. Harcharan absolutely had to pay up. Now, pause for a second, one else. Major warning, this is a classic exam trap, and law professors absolutely love to test the boundaries of this rule. You have to contrast the success in Harbhajan Lal with a total failure in another famous case, Laman Shukla v. Gari Dutt. In our case today, Harbhajan acted with knowledge of the offer, so he gets the payday. But in Laman Shukla, the claimant found a missing boy completely blind without knowing a reward had even been offered. Because he acted without that knowledge, the court said there was no acceptance, and therefore no reward whatsoever. I mean, you can't accept an offer you literally don't know exists, right? So if you see a general offer question on your exam, the very first thing you should ask yourself is this a Harbhajan scenario with knowledge or a Laman scenario without knowledge? All right, let's bring it all home with Section 5, Exam Review, Core Legal Principles. Let's cement these concepts right now. Think of this 4-step logical progression as your ultimate cheat code, your IRAC checklist for literally any exam question involving a general offer and a reward. If your professor gives you a fact pattern about a lost dog, a stolen car, or a missing person with a reward attached, just follow these steps. 1. Spot the general offer under Section 2A. 2. Prove the plaintiff had knowledge of the offer before they completed the act, otherwise you're falling right into that Laman trap. 3. Show acceptance by performance using the magic of Section 8. And 4. Conclude by establishing a binding contract under Section 2H. Hit all 4 of these steps in your analysis, and you're walking away with maximum points. So to quickly recap those established principles, a reward announcement to the public is a valid offer. The claimant absolutely must know about the offer before acting. Performance equals acceptance. Thank you, Section 8. And finally, once those conditions are met, the offerer loses all rights to back out. They are strictly bound by the law to pay that promised reward. Mere assistance transforms into hard contractual liability the exact moment those conditions are fulfilled. Before we wrap up this explainer, I want to leave you with a little brain teaser to ponder while you study. If acceptance in these general offer cases is proven just by your physical conduct, like literally just the fact that you returned the stolen goods, where exactly is the boundary of proving you truly acted because of the offer? I mean, how does a court truly know what was inside your head and that your actions weren't just pure 100% coincidence? It is a wildly fascinating gray area of contract law that keeps litigators very, very busy. Best of luck with your studying, keep reviewing those Section 8 principles, and you are going to do great on your finals.